that I have is Anthony DeBoos.
We are on the record in 2023 TR 2777, State of Kansas versus Anthony DeBoos. Devin Canfield for the state, the defendant in person, and with counsel Darren Patterson.
Your Honor, if I may.
Well, I'm not finding his file. It must not have caught up with the quick turnaround. So go ahead.
Your Honor, I did talk with Mr. DeBoos. I would tell the court that the sum of the conversation, or I guess the end of it, is that he is asking to represent himself. I would, in review of case law, Judge State v. Collins 257 Can 408, would suggest that he does have the right to represent himself and not have counsel appointed if it's at any stage besides trial.
This is where it begins, and you can already sense confusion brewing. The judge is calm, procedural, and professional, but the defense hints at something unusual. The defendant wants to represent himself. And not just that, he's about to take this courtroom into sovereign citizen territory.
And we're certainly not at trial yet, so that because of that, he does have that right. I think he wants to invoke that right and represent himself, Your Honor.
Mr. Patterson, he did make that clear to me at the last hearing, but he didn't seem to have all of the law in his proper grasp as the court saw it. And so I wanted counsel to be available to him in the event that he wanted to avail himself to it.
I can report we did have a very long conversation concerning the law, and I can tell a court there was just a difference of opinion about it. Mm-hmm. But okay. That's as much as I can tell a court.
I object. For the record, I am not representing myself, and I did not accept your forced appointment of Mr. Patterson onto myself. I am not representing myself. I am in propria persona as age of majority, handling my legal affairs as I need to, which is, again, as Mr. Patterson said, retain and attain my rights, and I shall not be abrogated from them. And I recuse Mr. Patterson from being a public defender for me.
Here we go. Anthony starts talking about trade names and all caps, phrases often used by people who believe legal names in capital letters represent corporate entities. It's a bizarre pseudo-legal belief system that has no standing in real law, but you'll see how confident he is in his misunderstanding.
All right, Mr. DeBoos, you're charged, as you may recall, with operating a motor vehicle without a valid license in Butler County, Kansas on August 17 of 2023. You were also charged in count 2 with operating a motor vehicle without registration or with expired tags on that same date, as well as in count 3, operating a motor vehicle without proof of liability insurance on August 17th of 2023. So again, that's no driver's license, no tag or registration, and no insurance.
I object before we move forward.
And under Kansas law, if you're going to operate a motor vehicle on Kansas roadways or federal highways or county highways, you are agreeing to follow the law that you will have a driver's license, have a licensed tagged car, and that you will have insurance on that car. Now, if you do not want to have counsel, I'll have Mr. Patterson, I'll ask that he be standby. At this time, you want to represent yourself. You say you don't want to represent yourself, but you can't.
Notice how the judge stays calm, explaining simple traffic charges. 3 misdemeanors, basic stuff. But to Anthony, this isn't about traffic law anymore. It's about sovereignty. And that's where everything starts unraveling.
Hold on, I object. This needs to be addressed first. Can Mr. Regier please show himself on the record in person for this matter?
Mr. Patterson, humor the defendant, or Mr. Regier, why don't you, for the humor of the defendant, show your picture, turn your screen on. I assume you're the one that charged the document. There you go. That's Jared Regier, the prosecutor that filed the case. He's not the witness in the case. The witness will testify at trial. So, again, you don't want an attorney to represent you. Is that right, Mr. DeBoos?
I do not want
Okay.
an attorney,
Thank you for answering
and I
this
need
question.
Mr. Regier to actually come on the record.
Okay, now, you're not in control of this hearing, sir. I'm appointed to do that, so you do not want an attorney. Do you understand that you could hire any attorney of your choice? And if you cannot afford an attorney, you can apply for court-appointed attorney. Do you understand that, sir?
Anthony insists the prosecutor must appear on record. The judge humors him for a moment, even gets the prosecutor to turn on his camera, but that still doesn't satisfy him. For these defendants, it's not about justice, it's about control.
I need
All right, you
to
comprehend it, and you don't want the attorney.
I need to know for the record the nature of the charges, who is the person or individual bringing the verified complaint as a sworn affidavit against myself or the accused legal entity.
As you made that clear, Mr. Jared Regier, you are the one that filed that affidavit, correct?
Your Honor, I'm looking at the information in this case. It does appear to include my name in the opening paragraph of the information.
All right, and I've already told you the nature of the charges. I've explained those to you both at the last hearing and this one. No driver's license is a B misdemeanor. If convicted, you could get 6 months in jail and a $1,000 fine. No tag is an unclassified misdemeanor. If convicted, you could get a $2,500 fine, or you could get a sentence 30 days to 6 months. And the no insurance as a B misdemeanor, it has a minimum fine of $300 up to $1,000, and it has a possible sentence up to 6 months. The next thing I need to know is, do you want a trial in this case?
Object. I need the affidavit to be produced.
He keeps demanding the affidavit, thinking that without it, the case can't proceed. The judge explains, file a motion for discovery. But logic doesn't work when someone believes the entire court is illegitimate.
I verbally motion right now for the affidavit to be produced on the record of the sworn affidavit to be produced on the record for the verified complaint.
Well, there are rules of procedure, and if you want to review the statutes, if you're going to represent yourself, I would suggest you do so, because those rules of procedure will tell you how to get that. Now, do you want a trial? That is, do you want to plead not guilty to these charges and proceed with a trial at a future date?
I need to know on the record what jurisdiction this trial is going to be in. Article 3, equity. Article 2, military tribunal, or Article 1, admiralty maritime law.
And
This
Your
will
Honor,
be under the jurisdiction of the state of Kansas, the District Court, 13th Judicial District. Someone had a comment?
And now, the jurisdiction talk. Admiralty Maritime Article 3. This is the signature line of sovereign citizen arguments. The tragedy here isn't just the absurdity, it's how lost these defendants are in a fantasy legal world.
Read the rules of evidence and follow them, Mr. DeBruce. Now, I'm going to give you one more time. Do you want a trial? And if so, do you want a trial to the court or a trial to a jury?
I want to object to the pro se comment. I am not pro se. I am in propria persona. And
All
I'm
right.
making that very clear on the record. And if this does go to trial, I retain and claim the Article 3 equity court, and I demand a trial by jury, grand jury of 12 jurors.
Well, you're going to get a trial under Kansas law of 6 jurors for a misdemeanor, not 12.
Anthony demands a 12-person grand jury. The judge corrects him. Misdemeanors only get 6. Watch how patient the judge remains, even when faced with outright nonsense. That's years of courtroom experience on display.
Sir, you're saying things you apparently don't know what they mean. They don't belong in this court. I'm going to set this. Counsel, any objection to setting this for jury trial? He has not properly made demand for jury trial.
Not by the state, Your Honor.
All right, we'll set this for jury trial. You must appear February 5th at 9 a.m. for your pretrial hearing. And you must appear February 7 and 8 at 9 a.m. for your jury trial. Your jury trial will be, again, February 7th and 8th at 9 a.m. Now, Mr. Patterson, I'd like you to be available unless you want to, again, take the position that I can't do that, but I would think for jury trial I could have you on standby. Would you agree or disagree?
Your Honor, I believe the court can order that I be on standby.
All right, thank you, sir. But Mr. DeBoos, if you're going to represent yourself, you've got a lot of law to learn because you're way out there in left field, as the cliche goes, and you're looking at some state matters. You're in district court of the state of Kansas, the 13th Judicial District. And if you're going to represent yourself, there are rules of procedure for this court that you need to familiarize yourself with rather than those that you're trying to draw upon from who knows what source. So
you can feel the judge's frustration here. You're way out in left field. Still, he keeps it professional. This is the fine line judges walk, maintaining order while dealing with someone who fundamentally rejects the system itself.
I object because I need to know the nature of this, whether it is common equity or it is admiralty for the jurisdiction.
I've told you the jurisdiction, sir.
No,
and
you
that's
have
all
not.
we're
I
going to
object
say on
and
that.
show on the record that the
Objection
judge
noted.
has not showed the jurisdiction and the nature of it.
For the final time, this is in the 13th Judicial District, the District Court of Kansas, and this is a traffic proceeding involving 2 misdemeanor crimes and an unclassified misdemeanor.
I object as the Sixth
Objection
Amendment.
noted,
I need
sir.
to know the nature of it, and you are not expressing and elaborating the true nature of it, whether it is in common equity or admiralty. Okay?
Sir, that will be anything. Is there anything else we need to address, Mr. Canfield, from the state?
No, Your Honor.
All right. Thank you, Mr. Canfield. Thank you, Mr. Patterson and Mr. DeBoos. That will be all until February 5th, unless counsel or defense files any motions that need to be set for hearing prior to that date. So,
Thank you.
Mr. DeBoos, you may go at this time.
Even after all this, Anthony still objects, claiming the court hasn't proven its jurisdiction. The judge calmly ends the session. And that's the most powerful part, when authority doesn't need to shout. Just facts, patience, and finality.